Hello, everybody, and welcome to History/Law Bite number 135, dated December 19th, 2020. I'm Walter, your mobile historian and blue-collar scholar. This History/Law Bite is entitled Buck versus Bell, 274 U.S. 200, 1927. If you've never heard of this case, you're in the right place, all right? Buck versus Bell was a landmark U.S. Supreme Court decision that addressed the issue of eugenics sterilization. Eugenics, essentially the old version of eugenics, was a controversial set of beliefs that felt that the human population could be cured of its genetic deficiencies in various methodologies, okay? Some of the ways that would be carried out would be sterilization, selective breeding, and perhaps other methods as well. But sterilization and selective breeding were the most common methods, which this belief system helped fuel what was known as scientific racism and certainly the concept of white supremacy. Eugenics in that era certainly strengthened the arguments for laws which prohibited whites and non-whites from marrying. As part of that scientific racism from that period emphasized the fact that non-whites were biologically inferior to whites. And therefore, by mixing, you would lower the mental competency of whites. Say something that was absolutely not acceptable. All right? So, eugenics sought to cleanse, all right, humans of these bad genes, okay? Bad genes that made people mentally disabled, morally reprehensible, disabled in other ways, and the two ways I just gave you, sterilization and selective breeding, were methods used. And it was a very controversial set of beliefs, both then and now, all right? Some scientists in the contemporary eras subscribe to new eugenics, but we're not going to get into that. If you want to know what that is, look it up. Its foundations come from old eugenics, but new eugenics essentially seeks to improve features of the human race rather than destroy. Okay. Like I said, just take a look at it. But at any rate, in this case, Buck versus Bell, Virginia enacted a mandatory sterilization law for persons judged to be mentally disabled. Okay? And that is exactly what Carrie Buck was perceived to be. She had been committed to a mental institution, and the state of Virginia needed to test its new law to ensure that it was constitutional. Carrie Buck would be the test dummy. And as such, the institution initiated a sterilization order against her. All right? This order was fought all the way through the Virginia court system. Okay? And they lost at every single level. The state of Virginia prevailed in its own courts all the way up to its highest court, the Supreme Court of Appeals. Okay? On appeal to the Supreme Court of the United States, Buck's lawyers argued that Virginia's sterilization law violated the 14th Amendment to the U.S. Constitution, both its due process and equal protection clauses, okay? They argued that the due process clause had been violated because the law inhibited the natural right of an individual to be able to procreate, okay? And it violated the Equal Protection Clause because others similarly situated to Miss Carrie Buck were not sterilized. Okay? So that was the question presented to the Supreme Court. Did Virginia's compulsory sterilization law violate the 14th Amendment's due process and or equal protection clauses? Okay? And in an 8-1 decision written by the Honorable Justice Oliver Wendell Holmes, the Supreme Court ruled that the law did not in any way violate the 14th Amendment's due process or equal protection clauses. Simply put, Mr. Justice Holmes, who was 86 years old at the time this case was decided, held that the petitioner's real argument against the law was not a procedural argument against the process to sterilize an individual, rather the substantive content of the law. And Holmes emphasized that the procedures involved to require an individual to be sterilized were more than efficient, as a hearing was required, and the result of that hearing could be challenged throughout the Virginia court system, in its circuit courts, in its appellate courts, and finally at its Supreme Court. Okay, so there was more than enough places of access for an individual to challenge the legitimacy of such an order if sterilization was imposed. All right. Only if you had exhausted all your appeals could the sterilization take place. So there was no issue with the process. Okay. Holmes made it clear. Okay. You have a hearing. Okay. And you can challenge those results all the way to the state's highest court. All right. There's plenty of access to the judicial process. There's nothing wrong with that. So Holmes destroyed any process argument. All right. And with respect to the substantive argument, okay, Holmes ruled that the Commonwealth of Virginia certainly had a compelling interest in the public welfare that outweighed any private interest in bodily integrity, as argued by Buck's lawyers, okay, that the law was so unjust and so unfair that it violated her fundamental right to procreate. And Holmes said, well, quite simply, you know what? State has a more compelling interest to prevent more mentally disabled people from being born. Okay, this is the logic that was used. Okay, the public welfare and not having society burdened with more mentally disabled people overrules any right to bodily integrity. To quote Justice Holmes from this case, he wrote that we have seen more than once that the public welfare may call upon the best citizens for their lives. It would be strange if it could not call upon those who already sap the strength of the state for these lesser sacrifices, often not felt to be such by those concerned, to prevent our being swamped with incompetence. It is better for all the world if, instead of waiting to execute degenerate offspring for crime or to let them starve for their imbecility, society can prevent those who are manifestly unfit from continuing their kind. The principle that sustains compulsory vaccination is broad enough to cover cutting the fallopian tubes. End quote. Okay? And it is from this case that Justice Holmes made the famous statement, 3 generations of imbeciles are enough. So Holmes is effectively destroying the petitioner's argument that the state of Virginia, all right, has no right to do this to carry Buck. You know, he is destroying that argument piece by piece and holding that not only does Virginia have this right to do it, but Virginia is acting as an inherent state power, but Virginia is acting in the public interest to prevent mentally disabled people from continuing to populate and add more mentally disabled people to society, thus creating a burden on society as a whole. Why are you even challenging this? You know, this is basically the force in Holmes' opinion here. Like, dude, can't you see the merit of what Virginia is doing? Duh. Okay. Of course they can prevent mentally disabled people from reproducing. Like, are you kidding me? Of course. So that was the holding of the court. Okay. Quite simply, that the process involved to sterilize an individual, okay, was more than adequate, all right, as a hearing was required and it could be challenged on several levels before sterilization actually took place. And next, the state of Virginia had a compelling interest in preserving the public welfare by prohibiting mentally disabled individuals from reproducing, thus potentially creating more burden on society, all right, as mentally disabled persons in their minds would produce more mentally disabled persons, okay? So the state had a compelling interest to prevent that from happening, all right? And their way of preventing that was to sterilize mentally disabled people. The state had a compelling interest in preventing the public burden from being increased, all right, with more mentally disabled people in society. That was the state interest. To prevent more mentally disabled people from being born, okay, eugenics at work, the state's interest, okay, in preventing that, and ability to prevent that was found through sterilization, okay, and that was viewed to be constitutional. So that's the holding in Buck versus Bell. All right, the process for sterilization is more than adequate, okay, and the state of Virginia had more than enough ability to do this, acting in the public interest. Their compelling interest was to promote the general welfare and thus not allow society to be even more burdened with more mentally disabled people. That was the holding of the court. All right. This decision drew one dissenter, Justice Pierce Butler, all right, who did not write a dissent. Okay. So with Buck versus Bell, eugenic sterilization laws, wherever else they might have been in America, were effectively upheld. All right. Interestingly enough, though, after the decision, these laws were scantily used in most places, with the sole exception of the state of California, which kind of went gung-ho with eugenic sterilization. 15 years later, in 1942, in the case of Skinner versus Oklahoma, the Supreme Court significantly undermined Buck versus Bell in terms of implementing that decision, but it did not overrule Buck versus Bell in principle or in holding, essentially. But the rationale in Skinner made it very difficult to implement such sterilizations under the logic in Buck versus Bell. And by the 1960s and 1970s, okay, sterilization in this format had virtually all but ceased to exist. All right, it's still done in certain places, but again, it was very hard to do after Skinner versus Oklahoma, but it still remained legal per se, just much harder to do. All right. Virginia's law, in fact, is still in effect, although it's been modified, of course. And today, though, you need to be at least 18 years of age. You must voluntarily submit to sterilization. And you must also provide written consent. And the doctor who is performing it must inform you of the consequences and must also tell you of other means of contraception. All right. So, like I said, Buck versus Bell is still a valid decision, but it has been limited throughout time, most significantly with the case of Skinner versus Oklahoma in 1942. Now, to Miss Carrie Bell herself, after this law was, after this decision was handed down, she was sterilized, but she had already given birth to a little girl who she named Vivian. All right. Vivian died in 1932. So she didn't live a very long life, and her death was caused by complications from measles. But Vivian was not thought to be mentally disabled. She had, in fact, performed very well in school, all right, prior to her death. And she even made the honor roll once. So I think there's legitimate cause to believe that the theory that mentally disabled people will naturally give birth to another mentally disabled person is severely suspect. Very faulty reasoning there, all right? And some scholars today have argued that Miss Carrie Buck herself was not truly mentally disabled, but was rather maybe slightly mentally disabled, certainly well enough to live on her own and care for herself, you know, but not to the extent that she was thought to be, okay? Ms. Buck lived until 1983 when she died at the age of 76, okay? And it is often believed that she was simply thrown in the mental institution by her adoptive family to save their own honor, as she had been raped by one of her family members, okay? So it was a very interesting case. This is a very interesting case indeed. And indeed, although controversial, it still remains a valid decision, having never been overturned. So again, once again, the sum of it all, quite simply, the holding in Buck versus Bell was quite simply that first, all right, the process involved from beginning to actual sterilization was a fully fluid and thorough one, all right, in which a person had the right to a hearing, and it could challenge that person could challenge the result of that hearing all the way up the Virginia court system, all right. So there was adequate process involved before a person was actually sterilized. So there's no violation of the Constitution here. And next, the Commonwealth of Virginia had a very compelling state interest involved here, and that was to prevent the state from being swamped with more mentally disabled individuals, okay? And the methodology of carrying that out was to sterilize those who were mentally disabled to prevent them from reproducing, okay? So there was no constitutional violation there either. No process, no substantive violation, and no equal protection violation whatsoever. All right. So that is the holding in Buck versus Bell. All right. So if you have any questions or controversies, leave them down below and I'll be happy to answer them. Okay. Take care. Stay safe out there. And if you have not subscribed to my YouTube channel, please do so. Just hit that little red button and that little bell, and we are in business. I thank you for listening. Again, take care, stay safe out there, and I'll talk to you at the next bite. Peace.